Welcome to the Virtual Center for the Study of the Constitution and Civic Responsibility, an ongoing inquiry into American political origins and evolving institutions. The Executive Director of the Virtual Center is Dr. Bill O'Brien. He's also your host for this conversation. Here he is now, Dr. Bill O'Brien.
Thank you, Bob Kincaid, and welcome to today's edition of the Virtual Center for the Study of the Constitution and Civic Responsibility. It is a pleasure to be with you for the start of another week on this Veterans Day, and I trust that that everyone has taken the opportunity today to reflect for at least a few moments on what the meaning of today is and what it's about and why it's important and who needs to be remembered today. Very important day and a holiday for a lot of folks. Not a holiday for some others. And so I welcome you to today's program. I invite you to participate actively in it. We do have a phone number. It is there for your use. The area code is 304 and the number is 658-3333. That's 304-658-3333. If you would like to express your thoughts, your ideas, considerations, suggestions, concerns personally to me on today's program or on a previous program or perhaps somewhere we ought to go in the future, by all means I would love to hear from you, and I do commit to the idea that I will make every effort to respond to an email that you take the time to send to me. My email address is waobrien906@gmail.com. That's waobrien906@gmail.com. It's been 5 days since we've been together here at the Virtual Center. I think from everything I read and hear, it looks like we may be getting our first taste of winter this week. At least here in the east and in the mountains. So it's an important week. It's moving toward the Friday of this week is the 15th of the month, so we are rapidly moving towards the middle of November. Thanksgiving is toward the end of the month this year. It's the 28th, and before long we will be into December, and everybody knows kind of what that means. It's time to polish up those credit cards and get ready. But because we've not been together for 5 days, I thought that I would at least open the program with a comment or two about our last program. If you remember, we were looking at some of the Federalist Papers, and most specifically in our last program together, we were looking at Federalist Papers 47 through 51, and we were looking at James Madison's analysis of what becomes the operating procedure for the Constitution of the United States as outlined in Federalist Number 10. Basically, sometimes it's difficult because when you get into the language of these particular individual Federalist Papers, it's very, very easy to lose sight of the overall context, especially of how this paper relates to the previous one, which in turn might suggest others to follow. What Madison was doing in these papers is eliminating, I believe, was eliminating all other options except the option which the convention which he employed in the Constitution of the United States in terms of the representative branch of government. The idea of enlarging the sphere of representation, thereby incorporating so many different competing interests and factions that order and stability is created principally by the fact that while every one of these factions or interest groups would seek power of the others over the others, the fact of the matter is because they are so many and because they compete with each other for influence, the thinking is that by pitting one against the other, or as he says in Federalist 51, by using ambition versus ambition, what you do is you create relative stability and make change very, very difficult. And so by dividing up the government into separate branches of government, legislative, executive, and judicial, and then in turn by taking the legislative branch, which the convention clearly recognized as being potentially the most dangerous because of the extent to which popular sentiment and passion and power in the representative government seem to go together in a Republican government, in a popular government. Consequently, the major violator, if you will, the major offender of order and stability and justice and all the other good things that make up a society during the Confederation period was the legislative branch, the power of legislatures in each state, because of a combination of focusing most power in the legislative branch coupled with a conscious effort to limit the power of the executive branch, going back to the colonial days and recognizing that the colonists' biggest problem with Great Britain, as it were, was a problem with royal governors. So they felt that oppression and tyranny was most likely to come out of the executive branch. So consequently, in the state constitutions that were written in and immediately after 1776 as a result of the Declaration of Independence, there seems to be a conscious effort on the part of almost all the states to minimize the power of the governor, enhance the power of the legislature, which effectively meant that you were putting power closer to the people of the states than it had ever been before. And if the people could organize, if they could overcome their differences and organize and create majorities, then that majority could dictate instructions to the legislature, thereby turning government into an agent of the people. And that's, according to Madison, what the major problem with the Confederation was, and that is the situation which, to Madison, initiated the need for reform at the national level, which ultimately comes in the form of the Constitution of the United States. And what Madison is doing in Federalist 47, 48, 49, and 50 is demonstrating for the reader a number of truths, if you will, about the nature of representative government. He basically points out, the first thing he does is take on, in 47, take on the anti-federalist criticism of the Constitution in theory because it violated the principles of Republican government as articulated by Montesquieu in Spirit of the Laws. Montesquieu believed that Republican governments had to be small in area because that was the only way that you could guarantee the reciprocal relationship between voters and the elected representatives. If government was really going to represent the best interests of the people, and if the people were going to have an opportunity to make their interests known to government, then by definition you're talking about a smaller area. And so consequently, many of the opponents of the Constitution opposed it because of the power that the national government was going to take. The thinking was that it would destroy the basis of Republican government. And Madison sets out, first of all, to demonstrate in these earlier papers, 47 and 48, that indeed is not true. And the way he deals with it is to point out, by going through every single state constitution, that the states themselves do not have constitutions which conform to the definition of republicanism that they are using to question the nature of the Constitution. In other words, Madison argues that what they are lobbying for is a continuation of the Confederation, when in fact the states, even though they are sovereign under the Articles of Confederation, are in no way republican themselves. They are too big and they, in one sense or another, violate the principles of republicanism that the opponents of the Constitution claim to stand for. And then he moves into the next issue, which is separation of powers. And he points out that the state constitutions, even though on paper they pay lip service to the principle of separation of powers, in fact, every single one of the states he addresses, he demonstrates, includes the opportunity of one branch of government to infringe on the independence of another. And his point is that even the states themselves are not strictly adhering to the principles of separation of powers, which again, enemies of the Constitution are using against it. Then the third agenda item or strategy that Madison takes on in these papers, 47, 48, 49, and finally 50, is to demonstrate that that in every Republican government, no matter how it's structured, power seems to naturally flow to the legislative branch. And what he's demonstrating is that in order to guarantee stability in society, in order to guarantee that justice and honor and stability and all the important things that are necessary in a popular government, in a Republican society, in order for those things to happen, there needs to be a way to check the natural tendency of powers in popular government to flow to the legislative branch. And what he points out is that even though there's an effort to maintain the semblance of separation of powers and a system of balance, a system of checks and balances within the system, the fact of the matter is that the legislative branch always seems to prevail. And then finally he takes on the fourth issue, which is Jefferson's proposal that there should be periodic conventions to revisit the Constitution and update it in order to meet frequent needs. And if you remember, Jefferson made the proposal that when 2/3 of two of the three branches requested it, there would be a constitutional convention. And Madison goes to great lengths to argue against the viability and the good sense of a second convention. Part of it is philosophical, but part of it is very practical. Madison realizes that a second convention at this time would effectively emasculate the Constitution that came out of the convention, the Philadelphia Convention in 1787. So as more and more talk begins to surface about a constitution, another convention, especially when people begin to talk about a Bill of Rights and the need for amending the Constitution, then logically people begin to talk about a second convention as a vehicle to consider amendments. And Madison is petrified, and that's one of the reasons he takes it upon himself to push a Bill of Rights as the first order of business in the new Congress. His principal goal is to derail the idea of a second convention. And in downplaying the benefits and the good sense of conventions, what Madison does is point to the existence of the passions of the people that play a distinct role in conventions, combined with the fact that the existing parties within the states will usually dominate any convention that happens. So in other words, while a convention to Madison seems to be a good way to go, he sets out to show that it's not a good way to go at all. And so finally, in Federalist 51, Madison ends up with a strategy. The only way to control the violence of faction then is to set up an internal system in such a way that by an internal system of checks and balances and separation of powers, you basically create power which offsets other aggressive power, and the sum total of that is stability. And that really becomes the strategy behind the national government under the Articles of Confederation. And again, the enlarged sphere and the idea of majority and minority factions and all of that in Madison's Federalist 10 and Federalist 51 relates specifically to the legislative branch, because that's where Madison anticipates most of the pressure and most of the threat is going to come from. There are people that are very concerned about the power of the presidency, but most people are more than willing to put that on hold because they recognize that George Washington's going to be first president, and nobody's worried about him abusing power. But later on, as parties begin to develop within Washington's administration, this fear of parties begins to rear its ugly head again. But basically, that's what we were talking about. So over the last couple of programs. So effectively, then, what Madison has done is to eliminate what seemed to be most of the more logical, common sense approaches to the issues of making or creating Republican government that can work. The point that I've been making over and over again here at the Virtual Center, and before we leave this, I want to make it one additional time, is that the unspoken reality here is that in the process of creating order and stability in this manner, what Madison has effectively done is shift power from the people's hands in a republic into the elected representatives' hands under the Constitution. Because it remains popular, because these are elected representatives, because of the people, the right of the people to express their will through the ballot box, the fact that government still, on the surface at least, derives its power from the consent of the governed, because these representatives achieve their power from the votes of the people who vote for them or against them. Doesn't matter. If you participate in the election, then you are consenting to be governed by the outcome. So whether you win or lose is not the issue. What effectively you are doing is legitimizing the right of government to make decisions. So in the process, what I believe is the real substance of Republican government, which is the ability of the people to dictate their needs and wants to government, that is sacrificed in ratification of the Constitution. And while the Federalists go out of their way to continue to call it republicanism, the fact of the matter is the people's ability to know and gain access to government on a regular basis is the essence of republicanism, according to Montesquieu. And in this process of ratification of the Constitution, that aspect of republicanism is gone forever. And so what Madison has effectively done, what the Federalists have effectively done in the Constitution, is eliminate a good portion of the threat of representative governments disrupting the balance of power within the three branches by ensuring that the people who are chosen to represent the voters tend to be the best people. Because the area, the constituency is larger, then chances are only the best people are going to be well enough known to win elections. So consequently, Madison's system not only achieves a shift in power itself, but it also pretty much guarantees that for the most part, the better people are going to be elected to represent the people. And so that also provides a solution to some of the concerns that Madison had. I think it's very, very important principle. And again, you can lecture on this stuff if you teach it in class or in government class or civics classes or political science classes or American, it doesn't matter. But you can lecture and lecture and lecture on this and tell people this, but until they actually read these papers and work it out for themselves how it works, they are left with no option except to memorize it. And so to really read these papers and understanding the thinking that went, that went into them, the thinking behind them, it's possible after a careful reading of these documents to pretty well come away with a pretty good understanding and appreciation of the strategies involved here. I think it's very, very important. About today's program, and probably tomorrow's as well, I had an issue. Let me kind of introduce an issue and then make you aware of a second, which I'm inclined to put off for a day, but you know, if there's more interest in this, then we could do it first. But one of the issues that has really confounded me for a long time in this whole issue is the apparent conflict, if you will, between conservatives and liberals today over the issues of natural rights. The idea, as in Jefferson's Declaration of Independence, the idea of inalienable rights to life, liberty, and property, and specifically the reliance on John Locke, and the extent to which the founders looked very, very directly toward the English radicals of the 17th century during the English Civil Wars of the 1730s and 40s, which resulted in 1749 in the beheading of Charles I, and the emergence of Oliver Cromwell as protector of the nation for 11 years until in 1660 the crown is restored in the person of Charles II. There's absolutely no question that the founders went to these English radicals for an awful lot of their arguments, which they in turn use against the crown in the movement towards 1776 and American independence. We talked actually months ago now about Cato's letters, the extent to which the Cato series, which appeared in the British papers in the early 18th century, used an awful lot of these arguments from 17th century British politics in order to make the case against government, against big government, against intrusive government, against tyrannical government, against an all-powerful monarchy, against the crown's claim to rule by divine right. All of these ideas designed to reinforce the principle of absolutism in government, the absolute power of government, come into question during the period when the colonists are beginning to put together their arguments against Great Britain, against the mother country, arguments which ultimately lead to independence itself. One of the things that has always bothered me is that when you look at American history later on, specifically after the Civil War, during the Industrial Revolution, it becomes very clear that the idea of individual freedom, which Jefferson talked about it as an inalienable right, life, liberty, and the pursuit of happiness. The idea of freedom had always seemed to me to change through the course of American history. It always seemed to me that Jefferson and the founders, when they talked about individual freedom, they had something very specific in mind. And it was not the kind of freedom that late 19th century conservatives point to when they start talking about economic liberty, the priorities of private property and the sanctity of contracts and all of these other free enterprise ingredients which seem to prop up unregulated free enterprise in the late 19th century which drive the Industrial Revolution in America. In other words, there seems somehow to have been a transition taking place so that when Madison talked about inalienable rights, he was talking about, it seemed to me he was talking about something moral and spiritual and philosophical. The idea that human beings, because they are creatures of a creator, were born with certain inalienable rights, the rights to be free, the rights to have choices, etc., etc., etc. And somehow, within the next century, all of these freedoms and rights seem somehow to have coalesced into a philosophy which pretty much justifies free enterprise, unregulated capitalism. In other words, somehow all the rights that Jefferson talked about seem to come together as economic rights. The rights to property, the rights to not be regulated by government, the rights not to be overtaxed or taxed by government, the idea that your property is sanctified and should be free and independent of government interference. I never could figure out where those things came from, but I always had a problem because there seemed to have been, in my mind at least, a transition taking place. What I'm doing is setting up something that I've been involved in over the last 4 or 5 days since the last time we got together here at the virtual center. And in the course of talking about this with friends and colleagues, I was reminded by a close friend, Bob Bliss, who is the Dean of the Honors College at the University of Missouri in St. Louis. Bob and I have been friends for more than 40 years. And in the course of exchanging thoughts and ideas back and forth with Bob reminded me of a book that we had read as graduate students in 1966. Now, you got to figure out how long ago this was. We're close to a half century. Bob and I had taken a class together in late 19th century Industrial Revolution in America. And in some ways, it was a course that was not memorable, but in other ways, it was. And Bob reminded me that one of the books that we were required to read in that course was a very small book by Robert McCloskey, who is a jurist, who writes an awful lot on the Supreme Court. He's written books on the Supreme Court, on American constitutional history, etc. And the book in question was published in 1964, and the title of it was American Conservatism in the Age of Enterprise, 1865 to 1910. And the author was Robert McCloskey. And I remembered the book. I remembered the cover. It was distinct about industrial America. But I really had forgotten the substance of the book until Bob reminded me. And specifically, what he mentioned that kind of triggered this in my mind, this happened last Thursday, I believe, is that in McCloskey's book, he was talking about those architects of conservative pro-business philosophy in the late 19th century who had very successfully taken the ideas of the founders and transposed them into a ringing defense of free enterprise capitalism free of government regulation. And specifically, the three people that McCloskey wrote about were William Graham Sumner, who in the minds of most people is associated with the idea of the gospel of wealth, Andrew Carnegie, who also talked about the idea of a gospel of wealth, the responsibilities of the successful to the community at large, And the third name in this triumvirate was Stephen J. Field, who was a justice of the Supreme Court in the late 19th century. He was not Chief Justice. But Field did an awful lot of writing and thinking at the time about the 14th Amendment. And Bob, in his comments to me in an email, made mention of something that I had totally forgotten. And he said, if you remember that book and what McCloskey was saying about Stephen J. Field, Field was able to take the 14th Amendment and turn it upside down to the point where the 14th Amendment was primarily for the benefit of business and corporations, not ex-slaves. And bells started to go off when I read that, because as many of the folks who tune in regularly to the Virtual Center know, I've been in the last 2 or 3 months very taken with the idea of corporations and the extent to which corporations have gradually throughout American history assumed the role of persons under the 14th Amendment. And specifically, the case that we've all been looking at is the 2010 Citizens United case, where the Roberts Court ruled that corporations, under their First Amendment rights to free speech, were entitled to contribute as much as they wanted to political campaigns. That all of this was in the context of political free speech, and thereby it was protected under the First Amendment. And also in Citizens United, the Roberts Court makes mention of the fact that persons under the 14th Amendment, in the minds of many people, included corporations. And that got me going 3 or 4 months ago, and I've been doing, if you remember, we looked at some of the early decisions of John Marshall, McCulloch versus Maryland, and the Dartmouth College case, where John Marshall talked about corporations as being people and the fact that this is really the direction that the nation should head. Suddenly, I realized I needed to get my hands on this book. And I apparently have misplaced my copy. I can't find it. But I did go to the library, to a local university library here, and they had it on the shelf, and I picked it up last Thursday. And so this weekend I've been reading it. And I've become absolutely enthralled with the philosophy of Stephen J. Field and the whole idea, because here's the answer to the question that I've been unable to answer, which is the transition in the idea of rights from spiritual and moral rights tied to human beings as human beings to the idea of economic rights focusing on materialism and quantification, and the idea of the sanctity of property. And McCloskey basically targets the dissents of Stephen J. Field in some major Supreme Court cases in the late 19th century as the beginning of conservative philosophical seizure, I guess it would be the best way, of the morality and the abstract nature of Jeffersonian ideals. And these have been hijacked and made part of the defense of free enterprise, unregulated capitalism in America. McCloskey's position is that Stephen J. Field's dissent in the Slaughterhouse cases in 1873 is really a seminal, pivotal point in American history, because this is the beginning of the process where conservative judges and conservative jurists have effectively hijacked the spirit and the essence of the inalienable rights of the founders and found a way to incorporate private property and economic freedom into Jefferson's formula of inalienable rights. I found this to be incredibly informative. And so what I've been doing yesterday, and if you want to get online yourself, you can do this. Just Google Stephen J. Field's dissent in the Slaughterhouse cases of 1873, and you will find copies of his dissenting opinion in that particular case. It's a very, very long, wordy, abstract, philosophical position. But what Field is able to do quite successfully is to use the rhetoric of 1776 to justify the unregulated economic growth of 1876 as the foundation for the Industrial Revolution in America. By arguing that whereas Jefferson defined life, liberty, and the pursuit of happiness as unalienable rights, Stephen J. Field is successful in adding property, economic freedom, and the right of every individual to pursue a calling, a career, a profession, as part of man's inalienable rights under this political system of ours. And so what struck me, and this is just an observation, but what struck me is that just as Madison and the Federalist had effectively hijacked the idea of Republican government by using it to promote ratification of the Constitution of the United States, when in fact the real substance of Republican government was being totally changed. Was being totally changed in the process. The rhetoric, excuse me, from a little bit dry throat here, I apologize. What effectively Madison and the Federalists had done is use the rhetoric of the founders and the rhetoric in support of Republican government to justify ratification of the Constitution, when in fact the new Constitution's ratification effectively took the major substance of Republican government itself out of the equation, off the table. There had been a major transition, shift in power as a result of ratification of the Constitution, but the Federalists continued to make the case that this was still Republican government, that they had not jeopardized or tampered the people's commitment to the idea of Republican government, the idea of popular government, the freedom of people to make their voice heard by government, and all the rest of it. So in a sense, all the symbols remain, the symbols of republicanism remain, while the substance is gone. I think I used the word duplicitous. Well, effectively, that's what Stephen J. Field does in order to take the founders and turn the founders into positive supporters and proponents of free enterprise capitalism in America. And many of today's conservative academics who are writing about the founders, This is part of the rebirth, the resurrection of the founders in American conversation today. What these defenders of free enterprise capitalism are doing is using the rhetoric of the founding to justify the specifics of free enterprise, unregulated capitalism, and a definition of the proper role of government which seeks to take government and force-fit it back into the very restrictive role that John Locke defines with ratification or approval of the so-called social contract and the creation of government when people choose to leave the state of nature by creating a government whose principal job is to protect their natural rights. But what these people have done, what Stephen J. Field has done, is add economic rights and property rights to those inalienable rights, thereby turning government into a protector of private property and private wealth. And under that system, the tremendous degree of inequality in the distribution of goods and services that we see in America today, the tremendous inequality of wealth and power that exists in America, becomes totally part of the game plan as defined by Stephen J. Field and the other defenders of free enterprise capitalism. This goes all the way back to the 19th century. It is absolutely incredible. And of course, the next logical step then would be to bring corporations into this mix and begin to emphasize the idea of corporations as persons, and the idea that the first 10 amendments to the Constitution, the so-called Bill of Rights, were an effort to protect the individual rights of persons. And since corporations are persons, then their rights become equally protected. And so what we have here is a very subtle, very shrewd, very sophisticated process of what I believe amounts to hijacking the founders in order to defend and support a particular economic theory. And here I'm quoting Oliver Wendell Holmes in his dissent in the case of Lochner versus New York in 1905. Oliver Wendell Holmes dissented against the decision in Lochner on the basis that in order to defend the majority of the courts striking down the New York State Legislature's efforts to regulate the hours and working conditions in New York's bakeries, the majority of the court strikes down that law as unconstitutional, as a violation of the individual's right to enter into negotiate contracts with employers. In other words, it violated the employer's right to seek and contract with individual employees, and it violated the right of each employee to negotiate a contract with his employer, and together to determine the terms of the employment contract. When the state interferes in that and begins to dictate nobody can work more than 10 hours a day or 60 hours a week, then the majority of the court found in Lochner that violated the individual's freedom of contract to make contracts for his own, to sell his own labor. And it was against that decision that Oliver Wendell Holmes dissented. And his position was, in order to support the majority on the court in this decision of striking down the New York bakery law, one had to support the idea of imposing and economic theory into the Constitution of the United States. Once the idea of freedom of contract and economic freedom becomes an inalienable right of each individual, says Holmes, then what you are effectively doing is denying the state its right to an exercise of its own police powers. You are denying government the right to promote the public interest or the general welfare. That all of that has to take a back seat, secondary status, to the idea of the individual right, the rights of the individual. And so, in effect, what Locke is based upon is a philosophy which is articulated in 1873, which is close to 30 years earlier, by Stephen J. Fields. And that becomes the turning point in the transition from natural rights, man's natural rights under the Declaration of Independence received from his creator as articulated by Jefferson in the Declaration, the hijacking of those, if you will, to become the philosophical foundation for free enterprise capitalism in America. And it's very obvious that those who have a vested interest and can gain from that transition will buy into it. And Stephen J. Fields' dissent in the Slaughterhouse cases is where that happens. And again, I have to thank my friend Bob Bliss, but more important, I guess I have to thank Robert McCloskey for his book entitled American Conservatism in the Age of Enterprise, 1865 to 1910. This book was published in 1964. There aren't that many copies left. I looked on Amazon and a lot of other places, and it's still available. But it's one of those books that over the years has people have forgotten about. I did. And it just answered for me many questions. So what I've done is I've pretty well reproduced the Stephen J. Field dissenting opinion. And what I wanted to do was focus our time together and see and look at exactly how Stephen J. Fields does this. It is absolutely brilliant. The way that Fields is able to pull this off. There are a couple of quotes that I wanted to share with you. Which I think are very significant in this. And one of them is a quote from the early American historian Carl Becker. We've talked about him before. Carl Becker was the author of the first major study of the Declaration of Independence, a kind of a line-by-line exhibition of the Declaration of Independence, its philosophical origins, etc., etc. Carl Becker was also the author of the study of local politics in the state of New York during the Confederation period. And Becker is the one that came up with the idea that there were two revolutions going on during this period, one of them for home rule and the other one being fought over who would rule at home. What he's talking about is the so-called internal revolution. Let me, if I can, share with you from McCloskey's book Carl Becker's quote on Jefferson's statement of liberal theology in the Declaration of Independence. McCloskey says that when Jefferson essayed a summary of liberal theory in his stately opening sentences of the Declaration, he gave testimony to the survival of the root democratic values. And he quotes Carl Becker as being a fairly lucid statement of this principle. And this is what Becker says. It, meaning the natural rights philosophy of the Declaration, It furnished at once a justification and a profound emotional inspiration for the revolutionary movements of the 17th and 18th centuries. Founded upon a superficial knowledge of history, it was, certainly, and upon a naive faith in the instinctive virtues of humankind. Yet it was a humane and engaging faith. At its best, it preached toleration in place of persecution, goodwill in place of hate, peace in place of war. It taught that beneath all local and temporary diversity, beneath the superficial traits and talents that distinguish men and nations, all men are equal in the possession of a common humanity. And to the end that concord might prevail on the earth instead of strife, it invited men to promote in themselves the humanity which bound them to their fellows, and to shape their conduct and their institutions in harmony with it. Carl Becker is obviously enraptured with the philosophical meaning and justification of what Jefferson wrote in the Declaration in his philosophy of natural rights. That what this did was point the way to a solution of the world's problems, which would be that there would be a general growing recognition of a common humanity amongst all people and all nations. And if we could build on that, and if we could promote it, and if we could use that to create symmetry and agreement amongst peoples, we could eventually overcome those things that divided people and divided nations and prompted war. Talk about optimism and idealism and positivism. This statement by Carl Becker is the substance of what Jefferson was doing when he wrote the Declaration of Independence in 1776. It was a statement of morality. It was a statement of humanity. It was a statement of God-given rights that all people held in common. It was the basis of human equality, not only in the nation, but in the world. That's what the founders believed to be the inspiration for independence. But lo and behold, after the Civil War, you get effectively an effort to pretty much take those things and twist them into the kind of support where equality becomes equality of opportunity in the economic system, freedom becomes the freedom to pursue one's calling, one's way of making a living, and these things are suddenly the same inalienable rights that Jefferson was talking about in 1776. McCloskey writes that even before Stephen J. Field wrote, Marx and Engels, oh, there's a name, there are a couple of names we know, Marx and Engels had already analyzed the development that Field illustrates. This is what they said. The bourgeoisie, the middle class, the business community, the bourgeoisie, whenever it has got the upper hand, has put an end to all feudal, patriarchal, idyllic relations. It has pitilessly torn asunder the motley feudal ties that bound man to his natural superiors, and has left no other nexus between man and man than naked self-interest, than callous cash payment. It has drowned the most heavenly ecstasies of religious fervor, of chivalrous enthusiasm, of Philistine sentimentalism, in the icy water of egotistical calculation. It has resolved personal worth into an exchange value, And in place of the numberless, indefeasible, chartered freedoms, it has set up that single, unconscionable freedom, free trade. So what Marx and Engels, in their criticism of free enterprise capitalism, are pointing out, even before Stephen J. Fields writes, is that what capitalism does is literally, I keep using the word hijack because I don't know what other word is more appropriate. It's taking the words and the language of the founders and transposing them into a different era and using them to support definitions which are quite different because they fit the economic realities of that time in that age. And it's a very, very short, easy, quick step from that to an argument that free enterprise capitalism is what the founders intended from the very beginning. Because Field has successfully employed or taken it upon himself to transition the words from the 18th century into the Industrial Revolution of the 19th century. And because the language of the founding has been appropriated by economic conservatives in the late 19th century, then it's not really much of a stretch to make the case that this is what the founders intended America to be all about anyway. The goal of America is to set up free enterprise capitalism state. And so suddenly you've not only appropriated the language of the founders, you've actually appropriated the founders themselves into this philosophical position. And the result of this is that you have some of the best history that has been written in recent years that is being driven principally by the assumptions of truth that rely on the writing of Stephen J. Field. Joyce Appleby, for example, one of the best revolutionary American historians that existed, who I was going to say she passed away, but I don't think it was. I think it was another woman historian who recently passed away. It was not Joyce Appleby, but Joyce Appleby wrote a book on capitalism, on the emergence of Western capitalism, and then she wrote a book entitled Inheriting the Revolution. And what she focused on was not the revolutionary generation of 1776, but the next generation, their children, those who were children during the years of the Revolution and ratification of the Constitution, and were in their 20s and 30s in the 1790s and early 19th century, early 1800s, when American capitalism began to take off. And of course, what she does is link the writings and teachings of the founders to the day-to-day life of these people, and thereby draws the conclusion that this is really what the founders were talking about, was the development of free enterprise capitalism in America. And obviously, modern-day conservatives took this and ran with it. They jumped all over it because it seemed a way to give new meaning to the founders. It seemed to be a way to use the founders to justify and provide substantive evidence to support the idea that not only was America intended to be a Christian nation by the founders, but also a capitalistic nation. And then they go to Madison and Federalist Number 10 and the priority that he gives individual liberty. And then they go to Locke and Locke's emphasis on the protection of private property. And when you put all of that together, you have created a philosophical coup. You have done something which is incredibly powerful. And you have created the kind of substance that those with a political economic agenda in the modern world can use to their own advantage. And I would suggest to you that the attacks on government, the attacks on Obamacare, all of the stuff is driven by the same set of assumptions and priorities. This is very important because what it suggests is that instead of reading the sources, doing the kind of research that helps us understand the past, what we are doing instead is cherry-picking the past in order to justify the present. The first is sound historical scholarship. The latter, I believe, is fraudulent. It's phony research. But as long as you can put Jefferson's name and Washington's name and Madison's name and all the rest of it under all of these quotes, and you can take these things out of context, you can imply that they are historically and substantively valid because of the names associated with them. But in effect, what you have done is totally flipped the meaning and the substance 180 degrees on its head. Incredibly important, valuable historical stuff, and directly related to the Constitution of the United States, which is, again, what the Virtual Center is all about. We have reached the top of the first hour here at the Virtual Center. We're going to pause and take a break for 5 minutes, and then we'll be back with our second hour, and I'm going to introduce those of you tuned into the Virtual Center to the writings and the thinkings of Stephen J. Field. He's one of those Chief Justices many people, he was not a Chief Justice. He was a Justice of the Supreme Court. He's one of those that some people probably have heard of, but nobody really ever knew anything about him or what he did or what he's responsible for or everything else. Hopefully after today that will change. But first, please stay with us. We're going to pause for a break, and we'll be right back. This is Bill O'Brien. You're listening to the Virtual Center for the Study of the Constitution and Civic Responsibility. We'll be right back. Thank you, Bob Kincaid, and welcome back to this Monday edition of the Virtual Center on this Veterans Day. For your participation and pleasure, we have a phone number. We invite you to participate actively in our program, especially with this stuff, because this is so abstract. I would love to hear your thinking and your ideas on this. Our phone number is area code 304, and the number is 658-3333. That's 304-658-3333. My email address, if you'd like to communicate with me directly, is waobrien906@gmail.com. That's waobrien906@gmail.com. If you are just joining us, welcome. We kind of set up what I believe is if you're just joining us, what we did in the first hour is pretty much set up the dissenting opinion in the Slaughterhouse cases of 1873 of one Justice Stephen J. Field. And Stephen J. Field is considered to be the turning point in American jurisprudence, where conservative pro-free enterprise industrialists in the late 19th century are beginning to very successfully appropriate the writing and the thinking and the verbiage of the founders in order to support their particular economic agenda. Freedom becomes economic freedom. The right to be heard becomes the right to enter into a contract. The right to accept the job, the right to negotiate your pay or your salary with your employer, and all the rest of it. So, in other words, the unalienable rights that Jefferson writes about in 1776 in the Declaration of Independence become transposed in the minds of Stephen J. Fields and those who follow him into the basic economic freedoms which stimulate and promote the development of what becomes free enterprise capitalism in the United States. It is absolutely brilliant, and it is extremely significant. It's important to keep in mind, then, that when you hear language from the founders about rights and freedoms and obligations and responsibilities and all the rest of it, they are moralistic and spiritual in their nature. Other people see them as economic and materialistic. And it's very, very important to pinpoint the priorities of the person using this language in order to make sure we know exactly what it is that they are saying. The key here, as McCloskey mentions in his book, American Conservatism in the Age of Enterprise, 1865 to 1910, the key is Stephen J. Fields and Fields' dissent in the famous Slaughterhouse cases. And without going into a lot of detail on context is always important, because meaning is enhanced tremendously by knowing the context, the situation in which certain things develop and certain things happen. The Slaughterhouse cases came about in the early 1870s in New Orleans, Louisiana. And there were all sorts of reports at this time, right after the Civil War, in and around New Orleans and all these parishes that, of course, experienced the horrors of Hurricane Katrina not too long ago. To make a long story short, effectively what was going on is that people were slaughtering their own animals, their own cattle, their own cows, their own pigs, etc. There were no rules and no regulations, and what people were doing was throwing the excess into the water system and into the rivers and the rest of it, and pollution and disease and filth and illness and death was rampant in New Orleans during this period. And finally, the state of Louisiana came to the rescue with legislation, and what they do is create a super slaughterhouse on the south side of New Orleans. And basically, what they did was forbid all of these other fly-by-night slaughterhouses, if you were, to continue to exist. And the assumption was, the idea was, that all slaughtering of animals would happen under one roof, one large roof, and it would be overseen and regulated, and people could rest assured that it was clean and sanitary, and that the meat produced was not diseased and all the rest of it. It was a classic example of the state using its police power to move in and enact legislation in the public interest. And of course, many of these smaller slaughterhouse operations filed appeals against the constitutionality of this particular law, and it ended up coming before the Supreme Court in the Slaughterhouse cases of 1873. And by a very narrow majority of 5-4, the court ruled in favor of the state. In other words, the court acknowledged that all sorts of versions of individual freedom were being jeopardized here. But the fact of the matter is that the situation was so dire and so dangerous that the public was right in looking to its government to come to the rescue and do something about this. And the state was merely fulfilling its responsibilities to the citizens it governs as promoting the public interest and protecting the general welfare. But there was a dissenting opinion written by Stephen J. Field, and it was supported by 3 other dissenting justices who voted no. And so Field's dissent is the position of the 4 justices in the minority of 9. The Slaughterhouse legislation won by a vote of 5-4. Excuse me. And this is the rationale. And I'm going to go through it very quickly because there are certain paragraphs, certain parts of this that I want to emphasize. Stephen J. Field says, and this is, I've excerpted key paragraphs from the decision. The Act of Louisiana presents the naked case, Field says, unaccompanied by any public considerations, where a right to pursue a lawful and necessary calling previously enjoyed by every citizen, and in connection with which 1,000 persons were daily employed, is taken away and vested exclusively for 25 years for an extensive district and a large population in a single corporation, or its exercise is for that period restricted to the establishments of the corporation, and they are allowed only upon onerous conditions. In other words, what the state of Louisiana has effectively done is create a monopoly for slaughtering animals in Louisiana. And the only way to get your animals slaughtered is to go through this operation and have it done by these people under their supervision. So as Field said, in the process of doing this, people have been denied their right to pursue a lawful and necessary calling. They've been denied the freedom that they always had to slaughter their own animals, previously enjoyed by every citizen, and in connection with which 1,000 persons were daily employed. It's taken away and vested exclusively for a certain period of time in one large corporation. That's Field's argument, that this is a violation of people's natural rights to freedom. He goes on and said, if exclusive privileges of this character can be granted to a corporation of 17 persons, they may, in the discretion of the legislature, be equally granted to a single individual. If they may be granted for 25 years, they may equally be granted for a century or in perpetuity. If they may be granted for the landing and keeping of animals intended for sale or slaughter, they may equally be granted for the landing and storing of grain and other products of the earth, or for any article of commerce at all. If they may be granted for structures in which animal food is prepared for market, they may equally be granted for structures in which farinaceous and vegetable food is prepared. Farinaceous is farina, it's grains. They may be granted for any of the pursuits of human industry, even in its most simple and common forms. Indeed, upon the theory on which the exclusive privileges granted by the act in question was sustained, there is no monopoly in the most odium form which may not be upheld. In other words, his argument is this decision forever forces us to live with the threat of monopoly, and the fact that at any time what we do for a living, what we do for our livelihood, could be taken away from us without warning and given to a corporation by arguing that it's in the public interest to do so. So that's Field's case. So then he puts the case, he tries to frame the question in a way which makes legal sense out of it. And he said, the question presented is therefore one of the gravest importance, not merely to the parties here, but to the whole country. It is nothing less than the question whether the recent amendments to the federal Constitution, he's talking specifically about the 13th, 14th, and 15th, the Civil War amendments, protect the citizens of the United States against the deprivation of their common rights by state legislation. In my judgment, the 14th Amendment does afford such protection and was so intended by the Congress which framed and the states which adopted it. What Field is basing his case on is the 14th Amendment. The 14th Amendment was passed after the Civil War to guarantee the citizenship and the equality of ex-slaves by basically guaranteeing them the privileges and immunities given to every other citizen, by making them citizens of the United States, Up until now, citizenship had been state-driven. If you were citizens of a state, then you were a citizen of the United States. What this amendment does is make these people who were not citizens of the states citizens of the United States, and indirectly, of course, by implication, citizens of the states in which they lived. And what Field is doing is suggesting that the 14th Amendment doesn't just apply to ex-slaves after the Civil War, which is the whole reason, the whole basis for the 14th Amendment. What Field's argument is the 14th Amendment is designed to apply to all citizens, not just the ex-slaves, but everybody. And of course, his suggestion here is, if you are denied the freedom to pursue your economic calling, if you are denied the right by a government-created corporation to pursue your own chosen career field, then you are effectively a slave. And that, in turn, means that the 14th Amendment applies to you, not just ex-slaves. He's taking legal language and he's twisting the 14th Amendment around for a specific purpose. Now he's referring to the 14th Amendment. And he said that amendment prohibits slavery and involuntary servitude, except as a punishment for crime. But I have not supposed it was susceptible of a construction which would cover the enactment in question. I have been so accustomed to regard it as intended to meet that form of slavery which had previously prevailed in this country, and to which the recent Civil War owed its existence, that I was not prepared, nor am I yet, to give to it the extent and force ascribed by counsel. Still, it is evidence that the language of the amendment is not used in a restrictive sense. It is not confined to African slavery alone. It is general and universal in its application. Slavery of white men, as well as of black men, is prohibited, and not merely slavery in the strict sense of the term, but involuntary servitude in every form. What he's doing is broadening the language of the 14th Amendment to take in the issue of economic freedom, the rights of the individual to be free economically. And where he's going to go is to transition this back under Jefferson's Declaration of Independence into an inalienable right. And once he is able to do that, then he has successfully imposed free enterprise capitalism and economic theory on the very essence of the constitutional structure of the United States government. Think about that. He has done what Oliver Wendell Holmes in the Lochner case objects to. He is effectively taking the priorities of economic free enterprise capitalism, and he is finding a way to incorporate them under the umbrella of the inalienable rights that Jefferson talked about in 1776. And again, once you make this connection, once Field is able to pull Jefferson from 1776 into 1876, then it doesn't take too much effort at all to take 1876 and project it back into 1776 when Jefferson originally wrote it. It doesn't take too much imagination to conclude that if the language works and it fits that well, then perhaps that's what Jefferson really talked about when he was talking about economic freedom anyway. Maybe what Jefferson was talking about with inalienable rights to life, liberty, and property, maybe what Jefferson was talking about is the sanctity of private property, a people's individual freedom to own property and have it protected by government. That's free enterprise capitalism. And suddenly the connection has been made, the fit has been consummated. And Stephen J. Field, in this particular dissent, pulls this off. Then Field continues with the idea of involuntary servitude. He says the words involuntary servitude have not been the subject of any judicial or legislative exposition that I'm aware of in this country, except that which is found in the Civil Rights Act, which will be hereafter noticed. It is, however, clear that they include something more than slavery in the strict sense of the term. They include also serfage, vassalage, villanage, peonage, and all other forms of compulsory service for the mere benefit or pleasure of others. Nor is this the full import of the terms. The abolition of slavery and involuntary servitude was intended to make everyone born in this country a freeman, and as such, to give to him the right to pursue the ordinary avocations of life without other restraint than such as affect all others, and to enjoy equally with them the fruits of his labor. Suddenly what you've done is you've taken the inalienable rights of liberty and you have transposed them into the economic right to pursue a job and to keep it. A prohibition to him to pursue certain callings open to others of the same age, condition, and sex, or to reside in places where others are permitted to live, would so far deprive him of the rights of a freeman and would place him, as expect to others, in a condition of servitude. A person allowed to pursue only one trade or calling, and only in one locality of the country, would not be, in the strict sense of the term, in a condition of slavery, but probably none would deny that he would be in a condition of servitude. He certainly would not possess the liberties or enjoy the privileges of a freeman. So what Field has successfully done here is link economic freedom to slavery, thereby connecting the 14th Amendment to man's freedom to pursue his calling in the marketplace. He has hijacked the 14th Amendment from a government effort to protect the rights of ex-slaves, and he has transposed the 14th Amendment into a philosophical, legal justification for free enterprise capitalism. And obviously, others are going to pick up on his efforts. He goes on, the provisions of the 14th Amendment, which is properly a supplement to the 13th, which abolished slavery. If you saw the movie Lincoln, it was about passage of the 13th Amendment, cover, in my judgment, the case before us, and inhibit any legislation which confers special and exclusive privileges like these under consideration. The amendment was adopted to obviate objections which have been raised and pressed with great force to the validity of the Civil Rights Act, and to place the common rights of American citizens under the protection of the national government. So basically what he's doing is saying the 14th Amendment imposes the responsibility on the federal government of protecting man's right to his economic freedom, the right to earn a living. And what that means is government does not have the right to create artificial monopolies which inhibit man's freedom to make these market choices for himself. And then Field quotes the key phrases of the 14th Amendment. He says, it first declares, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. So effectively what the 14th Amendment does is guarantee that everybody who is in the United States is a citizen of the United States, and secondarily of the state in which they live. Up until the 14th Amendment was the other way around. You are a citizen of the United States because you are a citizen of a particular state. 14th Amendment reverses that in order to achieve citizenship for the ex-slaves. And Field goes on. The 14th Amendment then declares that no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. So it basically creates on the federal government the responsibility to protect individual freedom, which up to this point had been a state's right. And the whole idea of due process of law was originally written into the Fifth Amendment, but it only applied to the federal government. Now in the 14th, that provision is now being applied to the state governments. The federal government is now saying the state governments must adhere to the ideas of not abridging the privileges and immunities of citizens of the United States, etc., etc., etc. And then Field goes back and quotes Calhoun and goes back to Dred Scott and talks about the issue of, in Dred Scott, about citizenship in the United States in reference to natives was dependent on citizenship in the several states. If you remember, Dred Scott applied for his freedom on the argument that his owner took him into free territory, out of a slave state, into free territory, and then brought him back into a slave state. And Dred Scott's argument was that because he had gone into free territory, that meant that he was no longer a slave. Therefore, he could not be re-enslaved by taking him back into a slave state. And so basically Field goes through the origins of Dred Scott in terms of the whole idea of citizenship. And these next couple of paragraphs, it seems to me, are the key of the whole decision. The whole purport of the decision, the use of the word purport is interesting. The whole purport, the purpose of the decision, was that citizens of one state do not carry with them into other states any special privileges or immunities conferred by the laws of their own states of a corporate or other character. That decision has no pertinency to the question involved in this case. The common privileges and immunities which of right belong to all citizens stand on a very different footing. These the citizens of each state do carry with them into other states, and are secured by the clause in question in their enjoyment upon terms of equality with citizens of the latter states. This is legal language, but I would suggest to you it's very, very important, because what Field is doing here is talking about the inalienable rights that Jefferson spoke of in the Declaration. As a human being, you were endowed by the Creator with certain inalienable rights. Among these are the rights to life, liberty, and the pursuit of happiness. Justice Field has just added economic freedom to that list. And what he's saying is, as a human being, you carry your inalienable rights from one state to the other. You don't leave them at the border. Now what he's saying is, since we have successfully included economic rights as an inalienable right, it means that they too can be taken from one state to the other and not lost because they have become inalienable. What he has successfully done is fused Jefferson's moralistic, spiritual rights that belong to human beings, and he has added economic rights, the right to hold a job and to sign contracts and to do all of these things without interference as a natural right. He has basically taken the Constitution of the United States and assigned it the responsibility to promote and protect free enterprise in American capitalism. My God, this is important. what the clause in question did for the protection of the citizens of one state against hostile and discriminating legislation of other states, the 14th Amendment does for the protection of every citizen of the United States against hostile and discriminating legislation against him in favor of others, whether they reside in the same or in different states. What Field is arguing that the 14th Amendment is basically the assigning to the federal government of the responsibility to protect people's economic freedom to go anywhere they want in pursuit of their calling and not be limited and not be subject to artificial legislative creations or monopolies or whatever which deny you your economic freedom. And this I have put down as the key paragraph to the whole document. Now, what the clause in question does for the protection of citizens of one state against the creation of monopolies in favor of citizens of other states, the 14th Amendment does for the protection of every citizen of the United States against the creation of any monopoly whatever. Field argues that the 14th Amendment makes monopolies which run counter to man's individual freedom as being a violation of the 14th Amendment. The privileges and immunities of citizens of the United States, Field said, of every one of them, is secured against abridgment in any form by any state. The 14th Amendment places them under the guardianship of the national authority. All monopolies in any known trade or manufacture are an invasion of these privileges, for they encroach upon the liberty of citizens to acquire property and pursue happiness, and were held void at common law in the great case of monopolies decided during the reign of Queen Elizabeth. And now Field is going all the way back to British history and is pointing out Britain's common law legislation which makes monopolies illegal. And he's going to suggest that since the colonies came over here and brought British common law with English common law with them, then if monopolies were unconstitutional there, then by definition they are unconstitutional here as well, because they violate individual freedom. So in a sense, what the 14th Amendment does is create an obligation, a responsibility on the part of the national government, the central government, to protect people's economic freedom to go wherever they go and do whatever they want to do, as long as it's legal and as long as it's within their natural rights to pursue their economic livelihood. The central government effectively becomes the protector of free enterprise capitalism in America under this philosophy, under this reasoning of Stephen J. Fields. Now he goes back to Great Britain and talks about common law. And he says the common law of England is the basis of the jurisprudence of the United States. It was brought to this country by the colonists, together with the English statutes, and was established here so far as it was applicable to their condition. That law and the benefit of such of the English statutes as existed at the time of their colonization, and which they had by experience found to be applicable to their circumstances, were claimed by the Congress of the United States in 1774 as a part of their indubitable rights and liberties. Of the statutes and benefits of which was thus claimed, the statute of James I against monopolies was one of the most important. And when the colonies separated from the mother country, no privilege was more fully recognized or more completely incorporated into the fundamental law of the country than that every free subject in the British Empire was entitled to pursue his happiness by following any of the known established trades and occupations of the country, subject only to such restraints as equally affected all others. the immortal document which proclaimed the independence of the country, declared as self-evident truths that the Creator had endowed all men with certain inalienable rights, and that among these are life, liberty, and the pursuit of happiness, and that to secure these rights, governments are instituted among men. What Field has done is take economic freedom and the economic requirements of free enterprise capitalism, and he has brought them all under the federal government for federal government protection and support, and he's justified all of it in Jefferson's Declaration of Independence by assuming that these rights are as important as the original inalienable rights of life, liberty, and the pursuit of happiness. And he mentions verbatim the Declaration of Independence. He has appropriated, he has hijacked the language of the founders and used it to support free enterprise capitalism in the United States and all that goes with it. So by assuming a role for the national government, which is one of protecting man's economic freedom, by definition, if your charge is to protect that freedom, then you sure as hell can't regulate it. You don't control it. You can't use a claim of promoting the public interest or the general welfare as a way to deny people freedoms which the 14th Amendment imposes upon the national government the responsibility to protect. You have rendered the federal government the agent of free enterprise. You are denying it the right to regulate and the right to control and the right to manage. You literally are denying government the freedom to govern by imposing priority status on the economic freedom of citizens to pursue their calling, to pursue a living. And then finally he goes specifically to Louisiana, which, as you may remember, belonged to the French before Napoleon ceded it to the United States. If it be said that the civil law and not the common law is the basis of the jurisprudence of Louisiana, I answer that the decree of Louis XVI in 1776 abolished all monopolies of trades and all special privileges of corporations, guilds, and trading companies, and authorized every person to exercise without restraint his art, his trade, his profession. And such has been the laws of France and of her colonies ever since. So if you don't like the British common law, the English common law, let's go to France. So what he's suggesting is that jurisprudence, legalism in the Western world limits monopolies in behalf of the individual freedom of people, and that once the United States, America, became an independent nation, it automatically assumed these same responsibilities and limitations. And finally, at the end of the report, he says, if the trader in London could plead that he was a free citizen in that city against the enforcement to his injury of monopolies, surely under the 14th Amendment, every citizen of the United States should be able to plead his citizenship of the Republic as a protection against any similar invasion of his privileges and immunities. And so now he's made the case. He's basically driven the last nail into this new definition of the role of the federal government. It might safely be said, he said, that it is one of the privileges of every American citizen to adopt and follow such lawful industrial pursuit, not injurious to the community, as he may see fit, without unreasonable regulation or molestation, and without being restricted by any of those unjust, oppressive, and odious monopolies or exclusive privileges which have been condemned by all free governments. And he goes on, there is no more sacred right of citizenship than the right to pursue unmolested a lawful employment in a lawful manner. It is nothing more nor less than the sacred right of labor. In all of these cases, there is a recognition of the equality of right among citizens in the pursuit of the ordinary avocations of life, and a declaration that all grants of exclusive privileges in contravention of this equality are against common right and thus void. This equality of right, with exemption from all disparaging and partial enactments in the lawful pursuits of life throughout the whole country, is the distinguishing privilege of citizens of the United States. To them everywhere, all pursuits, all professions, all avocations are open without other restrictions than such as are imposed equally upon all others of the same age, sex, and condition. The state may prescribe such regulations for every pursuit and calling of life as will promote the public health, secure the good order and advance of the general prosperity of society, but when once prescribed, the pursuit or calling must be free to be followed by every citizen who is within the conditions designated and will conform to the regulations. This is the fundamental idea upon which our institutions rest, and unless adhered to in the legislation of the country, our government will be a republic in name only. So says Justice Stephen J. Field.
Hey, Dr. Bill.
Yes, Bob.
Just a quick, well, you've got a caller. Mark is calling, and he's got a question for you.
Okay, go right ahead.
All right, stand by. Go ahead, Mark.
Hi, Mark.
Dr. O'Brien. Hi, Dr. O'Brien. How are you, sir?
I'm great, thank you. How are you?
I'm doing great, doing better now that I'm listening to an educated man like I have been, but talking to you and listening to you in person. I had a question in reference to Justice Field, sir. If you could give the audience your interpretation, how it would reflect on our country in reference to minimum wage standards, the Davis-Bacon prevailing wage standards, and also how it would affect, how Field's observation would affect the maybe not so constitutional right-to-work laws, though I'm sure that someone obviously must have made them that way, but in their interpretation, and I'll hang up and continue to listen to you, and I appreciate you.
Mark, thank you. I appreciate you so much, and my God, what terrific questions. I hadn't really thought about those specific examples you used, but clearly they're related. Because what Justice Field is doing is laying the groundwork for every conservative political position after that. In other words, there's absolutely no question. I haven't done a lot of this, but I've read quite a few of the constitutional renderings of a number of conservative justices, Taft being the major one, William Howard Taft. A lot of people don't give Justice Taft his good. Not only was William Howard Taft president of the United States, but he was also Chief Justice of the Supreme Court. I mean, no other president's ever been there and done that. He was also governor of the Philippines when we basically oversaw the securing of freedom of the Philippines from Spain in 1898. When we appointed a territorial governor over there, it was William Howard Taft. So his kind of experience and his kind of wisdom and jurisprudence is often overlooked. But in the little bit that I've done with Taft, the basis of his renderings, of his positions, are clearly tied to what Field is saying here. In other words, I don't have any doubt at all that McCloskey is right, that everything that happens after this is somehow grounded in this Stephen J. Field decision. And your position on minimum wage and right-to-work laws, it's very obvious that the major constitutional argument against minimum wage, now again, we're not talking about whether it's a good thing or a bad thing or whether it costs jobs and all that. Those are political questions.
Correct.
But the constitutional question is whether, in fact, to mandate a particular wage is a violation of the freedom of employer and employee to negotiate a contract between them. That's the major position, that in enforcing a minimum wage upon an employer, you're denying the employer the right to get the best labor for the least price, which is really what economic freedom is about.
Well, Dr. O'Brien, in that suggestion, could we not also make the same observation when it comes to being a free man in a slave state and a non-slave state? Is there much of a leap possibly in those comparisons to your earlier?
That's one of the things that he very subtly does in this document, Mark.
Mm-hmm.
He addresses the issues of Dred Scott and Dred Scott's argument that by moving from slave state into free territory, his status as a slave changed and he became a freeman. And therefore, once a freeman, he could not be re-enslaved. And that's the position in Dred Scott. And that's the position that the majority takes in the Supreme Court. But what Field has done is, before he can do that, he's got to take economic freedom and equate them with Jefferson's inalienable rights. In other words, the idea of life, liberty, and property. Once he makes the case that economic freedom is one of those inalienable rights, then just as you can take your liberty and your freedom with you from one state to the other, so also you can take your economic freedom. In other words, you can't take your freedom and move around and hold on to it until you make the case that it's an inalienable right, and he does that. And so he has to basically include economic freedom with Jefferson's unalienable rights before he can basically make the case that in these particular rights, man can go wherever he wants from place to place, and he always remains a human being, therefore he always retains these rights. And one of them is economic. And the same thing would be true with the right to work laws. In other words, the whole basis of right to work laws is anti-union, that nobody has a right to control your terms of employment except you. And so a right to work law, theoretically, is a state's right to reestablish man's individual freedom to negotiate free contracts between him and his employer. Of course, all of this is based on the idea that both sides are equally powerful and can negotiate from a position of equal strength, which is obviously absurd. You know, and that, I mean...
I apologize not to interrupt accidentally.
No, you're not.
Brian, it seems to me quintessentially possibly a question facing and has faced the world, and I make the observation that just being a blue-collar person, self-educated, that it's quintessential. My observation to what you just shared with the audience is, are we not a nation? Are we not a country? And though I think constitutionally the right to work description that you just gave from an educational standpoint seems to be legitimate from a layman's standpoint. I guess my final interpretation would be, are we not a people, a nation, and do we not have a right, and I'm not inferring that's what the professor's saying, to make a living wage to provide for a family within a nation, and not to be punished for transferring yourself from one location to another. Not saying when that's what the doctor's saying, but I'll hang up and continue to listen to you, sir, and I appreciate you being there for us.
Hey, listen, I appreciate you being there, and your questions are wonderful, and I thank you so much, and I know everybody enjoyed hearing them. Thank you, Mark.
Brian,
okay, thank you, buddy. I really appreciate it.
Semper Fi.
And Bob, are you there?
I am.
Okay. Did you had a comment too? We're getting close to the time. We got about 5 minutes left, and I don't want to shut anybody off, because I think the issues here are pretty significant.
Well, they very much are, and frankly, I wouldn't even be prepared to jump into what Mark was asking about without doing a little bit of digging around.
Oh yeah, exactly.
But you know, it's clear to me that maybe not necessarily from where, you know, from the standpoint of the distant past, but looking at where we are today, things that meant things that, and I think we've talked about this in the past, things that meant things constitutionally in previous generations no longer mean the same thing today.
Yeah.
There are things in the Constitution that the framers took for granted would always have the same meaning. That simply do not. And
Right.
and you know, there's a wealth of stories out there to that end. You know, I don't know if you saw it over the weekend, but does anybody really think that the Second Amendment right to keep and bear arms means that a bunch of gun fanatics get to ambush 4 moms meeting at a restaurant in a mall in Texas?
Yeah.
The cognitive dissonance has become so profound,
Right.
that I don't think. Well, I know the Tea Party likes to say that the founders wouldn't recognize this country, but I don't think they mean it the way that it actually would play out.
No, I don't think so. They made it either that way, Bob. And you know, it's really because this issue of freedom, when you take and Jefferson used the term when he talked about liberty, he was talking about the rights that human beings derive from being alive, from being born, from receiving these rights as a creator. When you impose economic freedom within that under that umbrella, then you're basically, in effect, defining or redefining a role for government which denies government the opportunity to govern in the public interest, to make decisions for the benefit of the whole society, because you're trying to transpose individual freedom into an absolute right.
Well, there's that, and then there's something that our buddy Dr. John points out, and that is that freedom is not defined or understood, I don't think, by Jefferson or Madison or Franklin or Adams or any of those other folks of that era. Freedom is not defined as the ability to choose between 29 different varieties of breakfast cereal.
No, exactly. No, we have, because free enterprise basically is comfortable with defining freedom as the availability of choices. But again, the system dictates the choices. But in theory, a real democracy would give the people the opportunity to determine the choices, not just which one is the best. And so by giving people the option to pick A, B, or C, and calling that freedom, you've really come up with a very, very skewed, slanted definition of the term in the process, and it's unbelievable. But I think Mark made the point that when you start talking about minimum wage and right-to-work laws and anti-union laws and all of these things, all of them go back to this grounding. I mean, this foundation is critical because all the contrary arguments are based upon it. And of course, the other issue that I think we'll probably get into tomorrow is this idea of the core curriculum in terms of education and what, you know, the debate over this, because it's a political and ideological debate as well. There's absolutely no question that this is what this is. I mean, this is the early 21st century version of the public school wars of the 1970s, for God's sake.
Well, sure, and what I think we're realizing is that we have reached a point where we can't have a discussion about whether water is wet without having some right-wing think tank out there hollering that no, it's bone dry.
Yep.
Because Milton Friedman said it had to be that way, or Ayn Rand.
And it's this idea that if your freedom is an absolute right, that means you can believe whatever you want, and because you are a human being with inalienable rights from the Creator, that means that your opinion is as good as anybody else's opinion. That's bullcrap.
Right.
You know, that's absurd.
And it stems from the fact that I think it's deliberate, Dr. Bill, that we quit teaching things like rhetoric and logic and the skills of argumentation. You know, I remember when you had the show a couple of months back about talking about students who, I don't want to get an argument.
Right, right.
You have to, but to be able to cogently lay out your
if you
position.
If you say anything, you've got to be able to support yourself. And the education system is not giving people the skills, the ability to do that. And that's what the Common Core does. It does imply many of these other things as well. So I think we've probably got a program coming up on that, Bob. No question tomorrow. But I really believe that this one, because I'll be honest with you, this issue of transition, how freedom became economic freedoms, is something for a long time that I couldn't put my finger on where it happened. It just seemed to happen, and this field decision is the one. I
think you've hit it right on its head, Dr. Bill.
It's absolutely incredible.
Well, it's been a Jim Dandy program today. I look forward to tomorrow.
We are out of time, and I guess it's your turn. So thank you all very, very much, and I'll be with you all tomorrow. Have a wonderful program. Stick with Bob, and have a wonderful evening. Be safe, and we'll get back together again tomorrow. Thanks, Bob.